The appointees cannot and should not have been made victims of it. For all those reasons, we go even further than the ultimate order passed by the learned single judge and direct reversal of the cancellation of the orders of appointment of the respondents as if they were non-est. The respondents are restored to their original appointment by the Director General without any interruption by cancellation. They shall be entitled to pay allowances and all benefits without any interruption. The appeals are dismissed. The writ petitions are disposed of by affirming the order of the learned single judge together with the modifications and directions made by us above.
Much.
Number 5 to 7.
Your Lordship, I am appearing on behalf of respondent number 4 in this
Yes.
matter, with Mr. Chatterjee.
You have arrived today from Calcutta or yesterday?
Yesterday night.
These are 3 appeals from the common judgment passed by the learned single judge, my lord. My lord, this pertains to a tender issued by the state government for procurement of...
You are for the appellant.
I'm for the appellant, my lord.
You are for the state of...
I'm for the state, Your Lordship.
and you?
Respondent number 4.
The writ petitioner, my lord. The challenge,
Petitioner.
they challenge the award of contract in my favor, my lord.
Award of tender in your favor.
The tender was awarded in my favor, my lord, and that was challenged by them. And the learned single judge directed for set aside everything, my lord, and directed for retendering the entire thing. Now, our case is, my lord, in terms of the tender document, they're required to submit bank guarantee and earnest money deposit, which they submitted in a different format, my lord, which was not accepted by the government. So that was challenged by them, my lord. In fact, there are 3 writ petitions filed. Number 5, 6, and 7 are 3 appeals against the 3 writ petitions, my lord.
What is the subject matter of the tender?
Procurement of aluminum roofing sheet, my lord, for BPL families, my lord. The state government, as a welfare measure, my lord, supplies roofing sheets, my lord, to below poverty line families every year, my lord. Now, that has been held up for quite some time because of the setting aside of the award by the learned single judge, my lord.
When was the tender awarded in your favor?
The tender was issued on 9 September 24, my lord. And tender was awarded on 4th of December 24.
24.
24. It's about 6 months, my lord.
And the time period within which the supply had to be made?
It was 6 months time, my lord. I'll just point out, my lord.
Impugn order. Last pata therefore.
$120 days, my lord.
Long over. Is there any stay?
By this honorable court, not.
There was an interim protection,
Not to issue fresh tender, my lord. That is.
yes, not to issue first tender, my lord, subject to correction from your lordship. And if when my learned friend will finish, I will, my lord, have the privilege to argue before your lordship that so far, if your lordship kindly peruse the impugn order, my lord, it is not the case, subject to correction from your lordship, that my client's tender has been issued or any of the respondents' tender has been issued. The honorable single judge observed for issuance of a fresh tender because My lord, our contention before the honorable single judge was, if your lordship kindly once take the trouble to come to page 38.
By cancellation of the agreement between the state and Dr. Mozika's client.
Yes, there was a, my lord, at the time of issuance of tender, my lord, clause 6 of the tender stipulates that all quotations should furnish a valid registration certificate registered under Investment Meghalaya as per Meghalaya Industrial and Investment Promotion Policy 2024. That is page 38. General terms and conditions. That was never adhered to. This condition was equally absent at the time of granting of the tender to my learned senior friend's client. So as your lordship knows, my lord, better than me, so far the Supreme Court honorable judgments are concerned, my lord, the conditions of the tender are not adhered to. It has not been complied. And this has fallen rightly by the honorable single judge. By setting aside the order, a fresh tender has been issued within a stipulated time for all the participants. If I am correct, subject to correction from your lordship. And
Page 38.
page 38, my lord. Clause 6. May I place again, your lordship?
Yes.
All quotationers, your lordship got, my lord? All quotationers should furnish a valid registration certificate registered under Investment Meghalaya as per Meghalaya Industrial and Investment Promotion Policy 2024. In the writ petition, our one of the contention was that this condition was not fulfilled and pick and choose policy was issued by the tender committee. If I am wrong, you will correct me, please, sir. This is one of the grounds. Another ground, if your lordship kindly comes to the memo of appeal, my lord, the oh, I'm sorry, my lord. জানেন পুরো ফাটাফাট ভুল করে ওই প্যারাগ্রাফ বলতে হবে, ওই তো বললে হবে। আগে এইটা।
What was the value? What is the value of the contract?
69 crores. And as for my instructions, my lord, from the client is concerned, my lord, advance has been paid by the appellant's company, only rupees 8.5 lakh. That is out of 30 metric ton, where actual value of the 30 metric ton is 1.03 crores. Tender is, my lord, subject to correction from your lordship, my lord, tender is for the poorer people so that they can get the facility of aluminium sheets in their house. But the way the tender process has been issued, my lord, it vitiates the process. That is my first core of submission. My lord, my second core of submission, my lord, subject to correction, if your lordship kindly takes the trouble to come to page 8 of the memo of appeal. Page 8. That is clause 2.6. Your lordship got my 2.6, page 8 of memo of appeal. এটাই তো memo of appeal. Yes.
Public interest.
Yes, I am deeply obliged. That public interest has been adversely affected in as much as catalyzation is writ large in the proceedings with two technically qualified bidders quoting the same price at double the market rates Whereas as per the aluminium sheet specifications, the going rate is 9,000 per bundle, while the work order has been allotted at rupees 17,500 per bundle. Your Lordship, kindly appreciate. I am pausing here for a moment. The tender was used for the poorer sections of the society to get them the aluminium sheets at the lowest rates. Now this is the 17,500 per bundle was allotted. And another thing is that only
My lord, if I would just, I have not even opened the case, my lord. If my friends are right, because what happened was the 3 appeals, I believe in one of the appeals the respondent is not represented, my lord. If Lordship wants, I can open my case, my lord.
Yes. This appeal is for hearing today.
Admission.
admission
For
stage.
admission.
I believe admission stage. Section 5 was allowed by your Lordship on the last occasion, and your Lordship has been pleased to extend the time for the fresh tender at the time of passing of the interim order. Madam. This was the earlier order of your Lordship. Order to the Judicial order.
Your offer was for 69 crores supply. Entire.
But here what government did, my lord, they divided the contract between me and the respondent in item number 2. I've been given 75% of the work, my lord, they've been given 25% of the work. Because the prices were at par, my lord.
But item number 3, we have filed a repetition, generating the award of 75 to the applicant and 25 to me, since both the parties have quoted successful both the technical and financial hits.
So, my lord, what happened? If I can just put in perspective, my lord, there was a tender, my lord. There were 3 bidders. I was one of the bidder. Mr. Sangresa's client was second bidder, my lord. And Mariam Commerce, the respondent in item number 3, was the third bidder, my lord. First bidder and third bidder were technically disqualified, my lord, at the technical stage, my lord, because of non-furnishing of certain mandatory documents, my lord. Now, the appellant before Lordship and Mr. Sangresa's client, they were successful bidders, my lord, but the rate quoted by them were at par, my lord. Same rate were quoted by both of them. So what government took a decision, my lord, to award 75% of contract to us and 25% to them. So item number 1 and 3, my lord, they challenged their technical disqualification, my lord, before the learned single judge. And Mr. Sangresu challenged award of 25%. His case was that, my lord, he should have given 50% of the work. The work should be divided half-half, my lord. What the learned single judge did, my lord, learned single judge, without appreciating the main point of contention, my lord, why their technical bid was disqualified and whether disqualification was correct or not. But that was the issue before the learned single judge, my lord.
On what basis your contract was cancelled? 75%.
But the learned single judge held that this tender process is not correct, you issue a fresh tender.
No, did his lordship hold that you did not have registration?
No, not on that ground, my lord. I'll just take your lordship to the operative part, my lord.
Come to paragraph 25, heard learned counsel of the judgment.
My lord.
Internal page 19.
My lord. May I read, my lord?
Yes.
Heard learned counsel for all the parties in these 3 writ petitions. The NIQ in question, as noted in the submission of the parties, is subject of much controversy, with the condition of the initial NIQ being challenged in WPC number 344 of 24. And in spite of corrigenda being issued amending the clause of the tender, is being questioned again as to the fairness in the process adopted by the tender committee in allotting the work to respondents number 4 and 5, though in unequal quantities. Even the work orders which have since been issued have also been assailed before this honorable court on the ground that the unequal allotment of the supply order has been made in a biased and arbitrary manner. To shorten the discourse, this court will attempt to condense the question involved and to examine the issues at hand as to whether judicial interference in exercise of powers under Article 226 of the Constitution of India is warranted at all, keeping in mind the limited scope of judicial review in such commercial matters. What firstly strikes this court is the ambiguity of the initial NIQ itself, which, when put under challenge in WPC number 344 of 24, had resulted in the issuance of the corrigenda as aforementioned. But this exercise, it appears, was not efficacious enough according to the petitioners in the instant writ petition, to ensure a free and fair bidding and tendering process. Without dwelling again into the details, only the decision-making process adopted by the tender committee will be scrutinized on the question of legality in line with the principles laid down by the Supreme Court in celebrated case of Tata Cell so-and-so. On the parameters as to whether the tender committee had exceeded its power, committed an error of law, breached the rules of natural justice, abused its power, or reached a decision which no reasonable tribunal would have reached. In the case of the petitioner in WPC number so and so, the rejection of the bid was firstly on the ground that instead of a call deposit, a fixed deposit in favor of the concerned state respondent had been created, which the petitioner contended was unfair, as fixed deposits are callable, and secondly, for supply of a West Bengal trading license, which was not accepted. In WPC number so and so, the petitioner's bid was rejected for non-submission of a partnership agreement, incomplete supply of technical specification, which was held to be contrary to clause 10 of the technical bid requirements, and absence of a valid trading license, which the petitioner contends is arbitrary, as a partnership deed and trading license are not mandatory for eligibility, and that the bid submitted included detailed project specifications. In WPC 37 and 25, the petitioners contended that the challenge of the work orders awarded to it and the respondent number 4 therein is due to the fact that though the petitioner and the respondent number 4 were technically and financially equal, the award of only 25% of the tender value to the petitioner and 75% of the respondent number 4 violates Article 14, 16, 19, and 21 of the Constitution of India. Thus, in the backdrop of these challenges, the decision-making process of the tender committee, as per the stipulations and corrigenda given in the NIQ, will be examined. In the NIQ dated 10/9/24, it has been stipulated at clause 3.6.13 under the general terms and conditions as follows. Every quotationer should furnish the company's firm's name, registered number on MIPP, full postal address along with contact details and email ID. Letter sent by email by the department to the address mentioned by the quotationer shall be deemed to have been received by the quotationer. Any change of details provided shall be duly informed to the department in time. Quotationer shall furnish a valid registration certificate registered under the Invest Meghalaya as per Meghalaya Industrial Investment Promotion Policy. The non-tribal quotationer should furnish the trading license from concerned district income tax clearance certificate of the past 3 years along with the tender papers document mentioned herein. And under the technical bid condition, clause 2 and 8 were as follows. The earnest money deposit in the form of call deposit, bank draft, demand draft drawn on any nationalized bank payable at Shillong pledged in favor of Director of Housing Meghalaya. Non-tribal quotationers should furnish trading license from concerned district council and income tax clearance certificate from the past 3 years. Thereafter, consequent to a pre-bid meeting, a corrigendum dated 23/9/24 was issued, whereby amendments were made to the NIQ in clause 13 of the general terms and conditions and clause 8 of the technical bid conditions, which was with regard to furnishing of a trading license from the concerned district council. Subsequently, on a writ petition WPC 344 of 24 being filed on 3/10/24, a corrigendum dated was produced before the court amending clause A of the general terms and conditions as to the requirement of having a manufacturing unit or industry in the state of Meghalaya, which was amended to preferably having their manufacturing unit or industries in the state of Meghalaya. As amended was also inserted, an amendment was also inserted to clause A of the financial bid stipulation. There, it has been given as follows. If the rate quoted by the petitioner is in the same stage, the provision of clause 8.1 of the Meghalaya Procurement Reference Policy for Micro and Small Enterprise shall applied, and the decision of the tender committee will be final and binding. If the rate quoted by the quotationer is in the same stage, the decision of the tender committee will be final and binding. That's the amended clause, my lord. The clause as stood above, after the corrigenda, therefore, was that as per clause 3 and 6 of the general terms and conditions, every quotationer was to furnish the company or firm's name registered under Invest Meghalaya as per the Meghalaya Industrial Investment Promotion Policy 2024. Further provision had by way of amendment to meet the contingency of bid being submitted at par by leaving it to the decision of the tender committee. The status of the NIQ after amendments for the sake of easy reference is illustrated in the chart below. Well, we may skip the table part below. From the chart above, it can be seen that the requirement of registration under Invest Meghalaya has not been subjected to any amendment, as also the requirement of valid trading license. To recapitulate, the bid of the petitioner in WPC number so and so was rejected on 2 counts, that is the non-furnishing of a call deposit and a valid trading license from the concerned district council. The petitioner in WPC number so and so was rejected on the ground that a partnership agreement and valid trading license was not submitted and detailed technical specifications not mentioned. Both the rejected bidders, however, were not rejected for non-fulfillment of the requirement of registration under the Investment Meghalaya. At this point, it would be useful to recall herein that this court, in the judgment dated 14/10/24, passed in so and so with regard to the Meghalaya Industrial and Investment Promotion Policy, had at paragraph 11, 12, 13 thereof taken cognizance of the importance of this policy, which had been framed for the economic development of the state, and had observed as follows. First, in the considered view of this court, it is important to note that the state of Meghalaya launched the MIPP.
You tell us once again when the contract was awarded, date of the contract?
But the date of
December
contract is
24.
4/12/24, my lord. 4th December 24.
And this tenders invited by advertisement when?
That was dated 10/9/24, my lord. 10th of September 24.
And have you begun any work?
Well, we have placed the order with our suppliers, my lord. But apart from that, my lord, what is the crux of the matter? If I may draw your lordship's attention, what was the actual dispute and what was the case of the period? My lord, may I draw your lordship's attention to page 40, my lord, the NIQ condition, my lord, in appeal number 44, the first item.
এটা আমাদের
Lordship, kindly come to page
And by
40.
the judgment, the tender has been set aside.
The entire process has been set aside, my lord. My lord, what the Leonard single judge director, I'll just read, my lord. Para 46. May I read, my lord?
Yes.
Accordingly, for the reasons aforementioned, the entire tender process pursuant to the NIQ dated 10/9/24 is hereby set aside. The consequential work order issued to the sub number 4 and 5 are therefore shall accordingly also stand cancelled. However, keeping in mind that the matter concerns the providing of free roofing seats to below poverty line families, which is vital to their shelter and well-being and in the greater public interest, the state respondents are directed to immediately float a fresh NIQ, citing clear and unambiguous requirement in terms of and conditions thereof, and further endeavor to complete the entire process, preferably within a period of 3 months from the date of this order. Now, my lord, the real dispute that was raised by them before the learned single judge, my lord, if I may draw your lordship attention to page 40, my lord, the NIT clause, my lord. But the clause requires them to submit a call deposit, bank draft, or demand draft, my lord, for the purpose of earnest money deposit. What they submit is, my lord, is something altogether different, my lord. And that was the primary reason that
That is all right.
রিটের ওই
But-
জায়গাটা দেখাও আমার যেখানে
page 40, lordship kindly sees, my lord.
সরকার নিয়োগ order
If from December 2024,
My lord.
the
license
contract has not been executed, say substantially, it is lying as it is. You wait for a couple of months, we will hear out the appeal.
yes
My lord.
And you also, in a contract like this, if you, the court will be slow to stop a public utility project like this. But if it finds that you were entitled to award of the contract
My lord.
and not he, you will be compensated in damages
I'm ready for that.
for the profit you would have earned, which in one Supreme Court decision has said 20% or something of the value is the expected profit.
My lord, so far, my lord, what fell from your lordship, my lord, his earnest money which he has paid, my lord, this 30 metric tons, 8.5 lakh. If I am being the successful bidder, after my lord final hearing from your lordship, I am ready to pay that. I have no difficulty. But the thing is that the hurdles which just now has been, my lord, submitted by my learned friends, already I crossed those hurdles. The bank
it-
has,
We are thinking only tentatively. If the court thinks
my lord,
that you should have got the contract and not he. That is
My lord. My lord.
that is the extreme.
Extreme. My lord.
That is, the cancellation of his contract will remain, and an agreement will be executed,
My lord.
directed to be executed in your favor.
My lord.
All right.
My lord.
That is the end of the matter. No,
My lord. My lord.
no exchange of money anywhere.
My lord.
But then if the court thinks that no, for 8 months, the contract is afoot, the contract is in their favor.
Okay.
So the winning party would be confined to damages, which the state will have to pay you.
My lord.
My lord, in fact, there are several decisions in similar lines, my lord, as Lordship has indicated, my lord, that if they are agreed, my lord, they can file for compensation, my lord, if they feel that they are unlawfully denied the participation. My lord.
Your
But I can satisfy Lordship that they violated the tender condition, and that was the reason the department rightly rejected the tender, my lord, at the technical
If
stage.
nothing happened, it is all right. Cancel one tender, float another one,
Well.
give it to somebody else. But then if it has made a run, 8 months, 10 months, 1 year, etc., and it's a public utility project, then the court would be a little slow.
Mostly meant for monsoons, my lord. Monsoons are already on the anvil.
My lord, no answer. What fell from your lordship, my lord, I understand. I bow down. My lord, no answer from my learned senior friend, which I prima facie place before your lordship so far violation of clause 6 of the tender is concerned, my lord. No answer, my lord. No certificate has been filed. That is there, my lord, coming from the tender committee at the time of, my lord, application. So, my lord, it requires fresh tender, my lord. Now, your lordship kindly fix a date, my lord, as fell from your lordship.
You tell us when it will be convenient. Earliest convenient date.
My lord, any Friday, my lord, subject to correction from your lordship, my lord. It is our
My lord,
privilege to appear
my
before your
lord, I'm
lordship.
praying except next Friday, my lord. Next Friday,
No, the paper book has to be prepared.
Yes, paper book has to be prepared.
2 weeks time, my lord. So I'll prepare paper.
All right. We formally admit this appeal.
Opposition direction, no.
Next. It is from a judgment and order dated 8th May 2025, passed by a learned single judge of this court in the exercise of his writ jurisdiction. Also by the impugned order, by the impugned judgment and order, this court cancelled a works contract in favor of the appellant and directed issuance of a fresh tender. Paragraph. The successful tenderer, the appellant, the state, and the unsuccessful tenderers as respondents are before us. Hence, we dispense with issuance and service of notice of appeal. Next, we expedite the appeal, dispensing with all other formalities. Advocate on record for the appellant shall file an informal paper book in this court. By 24th July, serving a copy thereof on the advocate on record
Well,
for each of the respondents. At least 7 days before the date fixed for hearing of the appeal. Next, list this appeal for hearing on 7th August, Thursday.
7 hours. Deeply obliged. My lord, only one indulgence I can pray. My lord, 7th I think is Thursday. Can it be 8th, my lord, subject to convenience?
8th August.
My lord, deeply obliged. Deeply obliged.
Number 8.
this is the matter pertaining to judicial officers, my lord, in the district council.
My lords had heard the appeal minutes where we had challenged the appointment.
Yes.
My lords had granted me some time to obtain instructions on the basis of what proposal had come from my friend.
1 minute, Mr. Paul.
Well,
The previous matter, you will make one composite order or separately? You need more time to seek instructions.
no, my lords, I've sought instructions. My lords, this actually acts only as a via media. My lords, the only issue that the petitioner, the appellants rather, my lords, wanted to point out before your lordships, which has already been placed. My lords, it not only affects the petitioner personally. Of course, my lords, only 2 petitioners had come before this honorable court. But there was an instance where as many as 66 advocates had actually, my lords, filed a representation with the respondents on this issue.
So what is this matter about?
My lord, this is pertaining to appointment of judicial officers in.
There was this
District
select
Council, my
list,
lord.
my lords, of
There were
3 posts. Initially appointed, my lords, 3
advertisement for
posts
3
was
posts, my lord.
carried over, and then, my lords,
Oh, he said 2 were vacant.
my lord.
Two are vacant, my
Yes,
lord.
what is your instruction regarding that?
My lords, I'm in a catch-22 situation. What the petitioner, what the appellant, my lords, want to highlight for your lordships is there were 66 petitioners, my lords, advocates who had made a representation way back before this post was filled up. Even if this via media is organized, my lords, it just accommodates just the humble appellant before your lordships.
But my lord, who have come before the court, this honorable court, my lord, originally 2 writ petitions, my lord, and in the appeal there is only 1 appellant, my lord. Even the other writ petitioner has
No, I have said, my lords,
yielded,
that's
my lord. He
my,
accepted the judgment of the learned single judge.
that's my lords.
Now, my lord, the appellant, the others cannot suit with from the shoulder of the appellant, my lord. He has come to court, my lord. We are giving him that much fairness, my lord, that he can if necessary, will condone his in case he is overage, my lord. Because the age limit is fixed normally at 37 years, my lord. If he is overage, will condone the age, my lord. He can participate. This was a writ petition, not even a PIL, my lord. In service matters, there cannot be PIL also, normally. So keeping balancing the interest of all the parties, my lord, as I suggested on the last date, my lord, 2 posts are vacant, will advertise. They can
What it
all of them they
essentially
can
does,
participate.
my lords, this
So
arrangement.
he also right, they are not before the court. And we are
My lords,
not,
I bow down. I bow down on that.
and we will say that you will start a selection process
My lord.
to fill up those 2 posts where you can
My lords, the
participate.
only issue here is that basically, my lords, a blatant illegality is, my lords, then, my lords, gets unchecked. That's the issue with which the appellant is here before your lordships. The law is settled, my lords. If the select list is for 3 posts, my lords, it goes. The finding of the learned single judge, my lords, that it was not for an anticipated post is, my lords, may not be correct in view of the my lords, dates, because the date on which the advertisement was made, 1 post was not even, my lords, in existence on that date. That was notified at a much later date.
My lord, my lord, without going into the merit, that is why I suggested, my lord, I proposed, I requested the district council also to finally settle this matter, my lord. We will advertise, and if he's overage, my lord, he will be allowed to participate. Because the judicial officers are there in office, my lord, and there is no allegation of any irregularity or any malafide in the entire writ petition as regards their selection, my lord. If there was something that they were either not eligible, my lord, for the post, or they are not qualified, or there was some discrepancy or some irregularity in the selection process, my lord, the district council would not have supported them.
That's not the issue, my lords, in these appeals. The issue is a little...
And they are in service for more than 3 years now, my lord. They are discharging judicial officers without any complaint, my lord. Because the problem, like we face, my lord, if they are unseated, my lord, after serving in the judicial post, my lord, for more than 3 years, to come back to bar, my lord, for them also, and they're young judicial officers, my lord.
These factors, my lords, could have been taken into consideration when these appointments were made in the first place.
And moreover, he participated in the selection process, my lord. He did not qualify in the written.
That's not the issue, my lords.
Stage, my lord.
The issue here is, my lords, that 3 posts are vacant. You make an advertisement. There's a select list of 6 people which come out. 3 are appointed as against the original vacancies. For the residual 3, my lords, that's where the difficulty begins. Lordships are aware. The law is, once the 3 posts are filled up, that select list comes to an end. Nothing survives on that. Now, my lords, you write a letter to this honorable court on the administrative side, and then you go ahead to make, my lords, appointments as against those 3 vacancies, one which did not even exist on the date on which the advertisement was made.
And my lord, the worst part was in the writ petition, the petitioners nowhere disclosed, my lord, that they participated in the selection process and they were unsuccessful candidates, my lord.
That does not have a bearing in this.
So we will hear. So we will
Let
hear it out.
the appeal be heard. I would only pray.
Heard out, and as an alternative, suppose the appeal does not succeed, we will say 2 posts are there. You fill it up. That is the alternative.
That direction can be given now also, my lord. The matter can be disposed of. That's been my
I am only praying my lords may hear the main matter.
My lord will leave all the questions of law open, my
According
lord.
to them, what I have understood that under the subject selection process, they were entitled to appointment. Now,
If those 3 posts are advertised, my lords, everybody gets, it becomes a level playing field for everybody.
as per the waiting list.
My lords, I would only pray, my lords, fix a date, and my lords may hear us on the main matter and dispose it off on merits. If I can establish a case, my lords, I'll establish it on merits.
Next week we will hear it.
Next week.
My lord, next week I have some difficulty, my lord. Maybe a week after that, my lord.
Any matter fixed that week, 18th onwards.
So it is not a case that, my lord, if we are unseated, he'll get appointed, my lord, because he did not even qualify the written test.
My friend.
So what I'm submitting, my lord,
that
that
is
is
the district council.
no, my lord, but that remains the fact, my lord. He is not a contender, my lord. He is not that he is a number 2 candidate, my lord. If I am unseated, he'll get. It's not that case, my lord. He did not even qualify the written test, my lord. Had he been as a number 2 candidate, my lord, and if number 1 candidate is unseated, he'll get the appointment. It's not a case. He is not even in the frame, my lord, as of now.
The issue is,
And
my
that
lords,
was the reason I was submitting, my lord, the matter can be disposed of in that line if Mr. Paul is agreeable to that.
my lords, I have instructions. I wanted to seek instructions specifically on this issue.
Because you will be throwing open the selection process,
Exactly.
confining the posts to 2, and 1 perhaps anticipated in August or September.
Yes.
But that includes 2, my lord, as of now.
That includes 2.
My lords may hear us on the, my lords, would 29th or 30th be convenient to my lords?
My lord, I am appearing for respondent number 4, 5 and 6.
Yes.
If a date is being fixed, my lord, for hearing on merit, my lord, I will suggest 5th of August, if your lordship can kindly fix it. Yeah, I have some matter, my lord, on 29 and 31st in Guwahati.
Fifth may not be possible.
4th, 5th, 6th, any day, my lord.
When did you say?
I said, my lord, 5th,
Sixth.
6th, 7th, any day, which is convenient to your lordship.
August.
My lord. First,
August.
Yes.
I'm okay.
List is appealed for hearing on 6th August.
6th of
My
August.
lord. All right.
I'll be back.
I live.
Number 9.
May it please the Lordship.
Yes.
Lordship, as per Lordship's last order, appellant was supposed to file an additional affidavit to bring on record certain documents which the appellant claims were crucial. We were supposed to receive a copy by 4th of July, my lord. We were supposed to receive a copy by 4th of July. I received a copy 10 minutes back, my lord. I seek some time to get some instructions on the documents that they have produced, my lord.
Documents to which effect?
I am yet to be honest, my lord, I am yet to go through the affidavit. There are 7 documents which have been attached. The importance or relevance of the documents, my lord, I'll have to take instructions, my lord.
Attached to the?
To the additional affidavit which was filed just today morning, my lord.
Who's for the appellant?
Mr. Pandey is used to appear.
My lord, my apologies. We are for the appellant, my lord.
Yes.
My lord, we have filed our affidavit, my lord, this morning. And my lord, the only difficulty is Mr. Pandey is on legs, my lord, before court number 4.
I'm seeking some time, my lord, to obtain instructions on these documents. About a week's time, maybe, kindly given to me.
Yes. Further to our order dated 24th June 25. Further to our order dated 24th June 2025. The appellant has filed learned Mr. Jindal appearing for the respondents. Seeks time to file. You filed a supplementary paperwork.
No, my lord, on the last occasion, my lord, we have submitted, my lord. Some documents will be pertinent, my lord.
No,
with
you
regard
were
to-
asked to file a supplementary paper. What have they filed?
They filed what
Additional
an
affidavit,
additional
my lord.
affidavit, my lord.
Bringing on record certain documents, my
And
lord.
filing was to be done by 4th of July. They filed today morning, my lord. But that's okay.
The further to our order dated friends. What have you written? An affidavit. Bracket instead of a paper book. Bracket closed. Bringing on record certain documents which it would rely upon at the time of hearing of the appeal. Mr. Jindal appearing for the respondents. Wants to file a rejoinder thereto. List this appeal on 23rd July. Rejoinder may be filed by 18th May with a copy served on the advocate on record for the appellant. Okay?
Obliged. Obliged.